Hey guys, welcome back. Today we're talking about topic 2.8, the judicial branch. In this lesson, you're going to learn about the foundations of the power of the judicial branch and the setup of the judicial branch. So let's get started. Article 3 sets up the judicial branch, mainly the Supreme Court. Other than the Supreme Court, Congress is actually responsible for creating what are called lower courts. Courts have different jurisdictions, or the legal right to hear a particular type of case. Original jurisdiction is the right to be the first court to hear a case. This jurisdiction is held by federal district courts. Original jurisdiction applies to both criminal and civil cases. There are 94 district courts throughout the country, at least one in every state, district, and territory. These are the courts that you think of when you think of court cases. There is typically one judge on a case at a time, a prosecuting attorney, a defense attorney, and a jury. Appellate jurisdiction is the right to review a case from a lower court. This is held by federal appellate courts. There are 13 federal appellate courts. These appellate courts are made up of judges who are nominated by the president and approved by the Senate. For these cases, there is typically a panel of 3 judges reviewing a case. There is no jury. For particularly important cases, all of the judges in the districts may actually sit in and make what is called an en banc decision, or an all-included decision. The Supreme Court is unique in that it has both original and appellate jurisdiction. It can also hear cases that come through state court systems. It is the only federal court where that is true. If you haven't already, you should take some time and get this diagram in your notes. If you need more time, pause the video here. The Constitution is vague about the size and makeup of the Supreme Court. Congress actually has the power to change the number of justices that sit on the court. In fact, after Lincoln's death, Congress wanted to reduce the influence that President Johnson had on the court, and reduced the size of the Supreme Court from 10 to just 7. After Johnson's term ended, Congress increased the court to 9, the size it is today. There are no constitutional requirements to be on the Supreme Court, except that a justice must have good behavior. We'll talk more about that when we talk about Federalist 78. But justices do have lifelong terms once they are nominated and approved by the Senate. To get a case heard by the Supreme Court, you need to be granted a writ of certiorari, which is a piece of paper saying that the Supreme Court is going to hear your case. This is granted when 4 justices agree to hear a case. That's 1 less than a majority vote would be. The court follows this rule of 4 to prevent the tyranny of the majority, or to prevent the majority ideals from trampling minority rights. In this case, when we talk about majority and minority, we're talking about political majorities and minorities, not racial. The only power given to the Supreme Court in the Constitution is the judicial power. Very quickly, it became clear that the Supreme Court must have a larger role if it was to share the weight of checks and balances within the government. Congress passed the Judiciary Act of 1789. While this act mostly created lower courts, it also gave the Supreme Court the power to assign writs of mandamus, or an order for another government official to do their job. In the first required case that we have, Marbury versus Madison, the Supreme Court said that part of the law was unconstitutional. While the court was losing its power to issue writs of mandamus in that case, they actually ended up gaining the power of judicial review, which has become an effective check on the power of the other 2 branches. They may have been giving up one power, but they were gaining an even larger power. The next thing that we're going to be talking about is Federalist 78, which is all about the judicial branch. And it introduces the idea that the judicial branch should be able to determine constitutionality. So the case of Marbury versus Madison didn't introduce the idea of judicial review. It was probably intended for the Supreme Court to have all along. Federalist 78 also introduces the idea of lifelong terms, but we're going to talk about that more in class. In this lesson, you should have learned about the foundations of power of the judicial branch and the setup of the judicial branch. If there's anything you missed, please go back and watch that part of the video again now. Then, answer the summarizing question in your notes so that you can get a stamp the next time we're in class. All right, guys, we'll see you later. Bye.